So hello everybody. Today we are going to look at company law FE1. So I've done numerous videos on company law in my YouTube channel. So just go to the playlist called FE1 and watch all those videos before you sit the exam. But I have some little updates for company law before you sit the exam that might help you. So the first one is Chempro Investments. So basically, this involved a liquidator who overcharged a company for services in a member's voluntary liquidation and ordered him to repay the money. It was a vastly disproportionate charging of fees that work had been carried out in what should have been a straightforward winding up of the company. So this is very relevant to your liquidation chapter in the ebook, and this would be a good case to mention because, so obviously in the statutory payout in liquidation, liquidators' fees are like right at the top, but it doesn't mean that that's a fait accompli. You can challenge the fees of the liquidator, and so this case is one for that. The other interesting thing is, so examinership has not been asked for a while in company law. I think it may be asked this time around, so March 2021, perhaps. So just know a recent big examinership that we had in Ireland was Norwegian Air. So I'm just going to go down through some of the details for you guys. It might be interesting. So the court noted that the struggling company had met serious challenges in recent times, obviously during COVID, with the airline only having 6 planes in use during the pandemic. So the High Court said that radical measures have been introduced, but still more is required. And the principal issue here was whether the parent company was sufficiently connected in Ireland to receive court protection in this jurisdiction. Because obviously examinership is protection for a certain amount of days, which can be extended from 70 to 100. So it was the Norwegian group that petitioned the court. So let's just go down. So the examinership application was made, and Kieran Wallace of KPMG was appointed as the examiner for the group. God, it's amazing that that guy is still around. I think he's basically done every single liquidation examinership in the history of the state. Feels like he's been on every single one. So the court was required to give a more detailed analysis of its jurisdiction to appoint an examiner over the parent company, which was incorporated and headquartered in Norway. The only assets held in Ireland were the shares of its subsidiary companies. This is why this case is interesting. Under Section 517 of the Act, the court has the power to appoint an examiner to a related company of an examinership application, and I actually didn't know that. So here, they looked at the legal test for entering a non-Irish company into the examinership system. And they looked at Harley Medical Group from 2013, which considered the criteria for winding up a non-Irish company. Now, this is quite detailed, as regards examinership law, but I think if you knew it and you were answering an examinership question, it would be a really interesting point to bring up about the related company coming within the protection of examinership. So in this case, the court determined that it had the jurisdiction to appoint an examiner over all the companies in the group. Having considered the evidence and the fact that no objections were raised by any creditors, the court was satisfied the companies had a reasonable prospect of survival, and the examinership process was approved. So this is Begasa Limited. So this is a High Court refusal from an application by the Revenue to declare that the receivers to a company failed to promptly discharge monies from the winding up of a company. Here it would tell the receivers were entitled to repay loans which were taken out to fund the receivership ahead of the preferential creditors. The revenue claimed the receivers had failed to comply with Section 440 of the Act because they had repaid the receivership loans before paying out to other creditors, but the court held that the receiver's costs of realising the assets and the receiver's own expenses must be paid out first of the proceeds of the assets before preferential debts are paid. So this is quite important because in receivership, you will always have, some claim of the revenue or whatever, but here the court held that no, the receivership, the cost of actually doing the receivership and the receiver's fees come before the revenue. So let's just go down to what cases they used to refuse the application. So under the Act, the court analysed the legal arguments and held that where there was a fundamental difficulty with the revenue's position that the receivership loans were secured liabilities. The court said that there was a specific clause in the debenture which deemed that receivership borrowings would be a receivership expense and that receivership expenses would be paid in priority to all secured creditors. Referring to Buckler v. Talbot, the court noted the English courts had determined that costs of preserving or realising assets and a receivership's remuneration ranked higher in priority than preferential debts in a receivership. The court was satisfied that this was also the correct position as a matter of Irish law. It held that receivership borrowings are distinct from company borrowings. So these were the loans the receiver had to make to pay off the debt. And it was done after they had gone into receivership. Secured by the debenture and are not affected by the priority given to preferential payments under the provision. There was also an interesting argument here made by Revenue that any costs, charge and expenses properly incurred in the winding up as per Section 617 fell within Section 440. But the court said that the priority of receivership costs derived either from contract or common law was not found in statute. So this broad brush cost, charge and expenses properly incurred in the winding up as per 617 does not mean the costs incurred in paying for a receivership. And actually that is a really good thing to remember for receivership law. The court also rejected the Revenue's claim for directions on the conduct of receivership under 438. The directions were sought as a preliminary step towards a wider review of conduct of the receivership, and the court said it was inappropriate to exercise the powers under Section 438 in this way. So they rejected the 438 argument. So yeah, this was a rejection of the application by Revenue. So that is very, very interesting. I'm going to include those cases as part of my company law ebook for anyone sitting company. Best of luck. Y'all know it's my favorite subject and I find it very, very interesting. And yeah, stay tuned for the next one. We're going to be doing property, equity, tort and EU. See you in the next one.